Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss another judicial pronouncement by the Honorable Supreme Court of India in the case of, in reference, Contagion of Covid-19 virus in prisons, Suo Motu Writ Petition, Civil number 1 of 2020. Wherein, vide order dated 7th of May 2021, the court provided certain reliefs in relation to the prison inmates lodged in the jails of India. Let us discuss the brief background of this case. In this case, the court discussed that on 16th of March 2020, it had sought a response from the government officials in relation to the immediate measures to be adopted for the welfare of prison inmates and juveniles lodged in remand homes. And vide order dated 23rd of March 2020, various high-powered committees were set up, and on the basis of their recommendations, lot of prisoners were released either on interim bail or parole. What is parole? Parole is temporary release of prisoner before completion of a sentence on the promise of good conduct. So lot of prisoners were released on these grounds. And when the active cases reduced, those prisoners were asked to report, and close to 90% of them have already returned to the prisons. The recent spike in COVID-19 cases in India concerned the court regarding the spread of the COVID-19 disease in the already overcrowded prisons that lack basic sanitation, hygiene, and medical amenities. The court observed that there are close to 4 lakh prison inmates in India, and rights of the accused persons must be taken into account by effectively managing the COVID situation in the prisons across India. Now let us discuss the directions that were given by the court in this case. The first direction was that no automatic arrests shall take place in cases of Section 498A of the Indian Penal Code that provides for the punishment when the husband or relative of husband of a woman subjects her to cruelty. And it was also observed by the court that such arrests are to take place only after compliance of Section 41 of CRPC that provides for when the police may arrest without a warrant. All the guidelines relating to when the police may arrest without a warrant have been provided under Section 41 of CRPC. The second guideline of the court was that the mandate of Section 41 of CRPC must be complied with in letter and spirit, and when the accused is produced before the magistrate, he shall peruse the report furnished by the police, and only after recording his satisfaction, the magistrate will authorize detention. Thirdly, the court said that even the decision not to arrest needs to be forwarded to the magistrate within 2 weeks from the date of the institution of the case. Fourthly, it was observed that notice of appearance under Section 41A of CRPC that talks about notice of appearance before the police officer needs to be served on the accused within 2 weeks of the institution of the case. Fifthly, failure in compliance of the directions that we just discussed shall render the concerned officials liable for departmental action and contempt of court before the concerned high courts. In the same manner, authorizing detention without recording of reasons shall render the concerned magistrates liable for departmental action. Sixthly, the court said that all these directions will be applicable on all the offences that are punishable with imprisonment for a term that is 7 years or less. So earlier the court said that these directions will be applicable only in cases of Section 498A, but in the sixth direction the court made it clear that these directions will be applicable on all the offences that are punishable with imprisonment for a term that is 7 years or less than that. Seventhly, it was said by the court that the high-powered committees shall consider release of prisoners either on interim bail or parole based on the guidelines framed. Then the court said that all the prisoners that were released pursuant to the order dated 23rd of March 2020 should be released by imposing appropriate conditions in order to save valuable time. The court was very concerned with the COVID situation, and the court rightly thought that these prisoners should be released based on the earlier guidelines and by imposition of appropriate conditions. The ninth direction of the court was that people who were granted parole earlier in the year 2020 should be granted a parole for a period of 90 days in order to reduce spread of COVID cases. Basically, the objective of the court is to decongest the prisons and to make sure that the prisons are not overcrowded at the time of COVID-19 pandemic. The court also said that the decision of the high-powered committees and the prison occupancy status needs to be updated on the concerned websites of all the states in order to enable effective dissemination of information. An interesting point was made by the court that not all prisoners would want to get released from the prisons owing to their social status and fear of contracting COVID-19 outside. The concerns of such prisoners need to be considered in proper perspective by the authorities. This was specifically stated by the court. And the prisoners who are still imprisoned, even after all this interim bail, parole, even after all these measures, the prisoners who will still be left in the prisons, they must be provided proper medical facilities, and spread of disease should be controlled in prisons by proper testing and immediate treatment. Lastly, it was directed by the court that daily hygiene and sanitation is required to be maintained in the prisons, and considering the lockdown and curfew situation, appropriate steps for transportation of released inmates shall be taken. So what are my concluding remarks? I find it to be a much needed order by the Honorable Supreme Court. Ideally speaking, when the high-powered committees had already been set up in the last year, they could have taken this decision on their own. But such is the dire state of affairs that the court was required to intervene to look after the welfare of the prison inmates. Rights of the accused persons and prisoners cannot be taken lightly. Such persons are a part of the society that we live in, and many of them are languishing in jail in respect of cases in which they might be finally acquitted in the future. Some of them are languishing in jails because of want of proper legal aid. It is the responsibility of the state to take care of all the prisoners, and such responsibilities have been statutorily provided. It is high time that prison reforms become a reality in India, and not just prison reforms, the trials need to be expedited too. All the concerned stakeholders must put their petty differences aside and implement the countless directions that have been passed by the Supreme Court in this regard. I really feel that if the directions passed by the Supreme Court are implemented in proper perspective and within time, then it would provide a big relief to the prisoners and their families. It is not just the prisoners whose lives are at stake. Those prisoners have families, and many of them are required to be with their families owing to the pandemic situation. Some of their family members are ill, there is financial crisis everywhere. And since close to a month has already been passed when this order was dictated by the court, I sincerely hope that the states and the union territories have implemented these directions by now. So I hope you enjoyed listening to this show. For more on reforms in criminal trials, you may visit my earlier posts on YouTube as well as Desi Kanoon blog. Thank you for listening. If you have any comments, feel free to make them in the comments section. Please do not forget to like and subscribe us. See you next time. Till then, stay tuned.